Hello friends, I welcome you all to lecture number 2 of practice series of Clat lecture series. These classes are sponsored by Sri Jendra Rank Zone. I am your mentor, Shekhar Gehlot. So now let us get back to our MCQs or question answer series. You know the principles and you know the way how to solve them. We have discussed it in the previous classes. So we are not going to discuss brief intros in each and every class now. So let us come straight to the question. Principle: interference with another's goods in such a way as to deny the latter's title to the goods amounts to conversion, and thus it is a civil wrong. So now first understand the situation. It says interfere with another's goods belong to someone else, you are interfering with them in such a way that you deny latter's title, that you are denying title to this person, that you are saying that you are not the owner of your goods, amounts to conversion. It is called conversion. Okay, and thus is a civil wrong. It is an act intentionally done inconsistent with the owner's right. This act is done intentionally and it is inconsistent with the owner's right, though the doer may not know of or intend to challenge the property or possession of true owner. Okay. R went to a cycle stand to park his bicycle. Seeing the stand fully occupied, he removed a few bicycles in order to rearrange a portion of the stand and make some space for his bicycle. He parked his bicycle properly and put back all the bicycles except the one belonging to S. In fact, R was in a hurry and therefore he could not put back S's bicycle. Somebody came on the way and took away S's bicycle. The watchman of the stand did not take care of it, assuming the bicycle was not parked inside the stand. S filed a suit against R for conversion. Now, what has happened here is someone went to a cycle stand and stand was fully occupied, so he removed some cycles and parked his own cycle, and then he put back all the other cycles, but because cycle had the capacity for only cycle capacity was full, so one cycle was left out, that was cycle belonging to S. So now because S's cycle is now out of the stand, it got stolen. Now S wants to file a case against R. Let us see what has happened here. R could not be held liable for the negligence of the watchman. Now this option says watchman was negligent. Watchman should have taken care. But let us see, watchman did. The watchman of the stand did not take care of it. Did not take care of it means as a cycle, assuming that bicycle was not parked inside the stand, because watchman thought that because the bicycle is not parked inside the stand, why should I take care of it? Okay, S would succeed because R's act led to the stealing of his bicycle. S would not succeed because R did not take away the bicycle himself. R has not himself taken away the bicycle. S would not succeed because R's intention was not bad. R did not have intention which caused stealing of the bicycle. But let us apply the principle now. Interference with another's goods in such a way as to deny latter's title to the goods amount to conversion. Now, has someone interfered with S's cycle in such a way that now S no longer has the possession or the ownership of the cycle? Yes, it has happened here. It's a civil wrong. Okay, it is an act intentionally done inconsistent with the owner's right. This act is intentionally done, which is inconsistent with the owner's right. The act is inconsistent with the owner's right. Here it was owner's right to remove the cycle from the stand, but R has removed it. This act is inconsistent with the owner's right. Okay, and it has been done intentionally as well. Though the doer may not of or intend to challenge the property or possession of the true owner. Though he R may not intend to challenge the ownership of the S, or he may not intend to steal it himself, but his act has led to the convergence. So, if we apply this principle to this fact, what appropriate answer would come? Appropriate answer would be S would succeed because R's act led to the stealing of his bicycle. Okay, this is the answer. If we apply the principle to the fact, answer would be that S would be liable. S would succeed and R would be liable because it was R who removed the bicycle. Removing the bicycle was the right of the S, who is the owner. But R did it. Intentionally, he removed it without owner's permission. And his act led to the stealing of the bicycle. Okay. So his act led to the conversion of goods. But he did not intend to get it done this way, but ultimately it is because of his act. It has happened and his act was intentional. Okay, so in this case, his act may not be intentionally to get it stolen, but intentionally he did some act which ultimately resulted in conversion. So now he is bound. Definitely, thief, if caught, is also bound, but this person is also bound. So answer would be B in such case. Principle: whosoever by his act or omission causes environmental pollution shall be held liable for any loss caused by such pollution. It shall be no defense in such case that all due diligence or reasonable care was taken while carrying out act or omission in question. It simply says anyone who is polluting the environment shall be guilty irrespective of whatever care or diligence he has taken. But if pollution is happening, he is responsible. Now apply this principle to the facts. Let's read the facts. Hari is carrying on a chemical and fertilizer industry near a bank of a river. In order to prevent and control any kind of harm to the environment, suitable waste treatment and disposal plants were installed in the factory. Due to some sudden mechanical technical problem, these plants ceased to work properly and therefore caused environmental pollution, which ultimately caused substantial harm to the environment and the people living around the factory. Victims of such pollution file a suit for suitable remedy. Now, his factory has polluted the environment, but what had happened is due to some sudden mechanical or technical problem, sudden problem was there. These plants ceased to work. He had put some disposal plants, but this ceased to work due to some technical fault which resulted into the environment pollution. Now apply the principle to the facts and let us see the options. Victims cannot succeed as necessary precautions to prevent any harm were taken by Hari. Victims cannot succeed as the mechanical technical problem was sudden and therefore beyond the control of Hari. Victims can succeed as it is the duty of Hari to see that no harm is caused to the environment and people due to his activities. Victims could succeed if treatment disposal plant were not installed in the factory. Okay. Now two options which say victim cannot succeed and victim cannot succeed. But definitely environmental pollution has happened, so people have a right to file a claim and they will definitely succeed as well. So now we are left with only two options. Which is the most appropriate here? Victim could succeed if the treatment disposal plant were not installed in the factory. Victims could succeed as it is the duty of Hari to see that no harm is caused to the environment people due to his activity under any circumstance. Now let us read the principle. It says it shall be no defense in such case that all due diligence or reasonable care was taken. That means he can have no defense here. Ultimately the correct option would be C in such case. Principle: qui fecit per alium fecit per se. This is the legal maxim which we discussed in the legal maxim class, which means he who does things through others does it himself. Okay, he who does things through others does it himself. This is also the underpinning principle for principle of vicarious liability. Facts: Nisha, the owner of a car, asked her friend Saurabh to take her car and drive the same to her office. Now Nisha is the owner of car. She gave the car to Saurabh and asked him to drive the car and take it to office. As the car was near her office, it hit a pedestrian Shrikant on account of Saurabh's negligent driving and injured him seriously. Okay, now Shrikant files a suit for damage against Nisha. Okay, the car belonged to Nisha, she gave it to Shrikant. Okay, and she gave it to Saurabh, and Saurabh hit Shrikant. Now, driver is Saurabh, person was got hit is Shrikant, but the car belongs to Nisha. And now Shrikant has filed a case against the owner of the car. Let us see what is it. Nisha is not liable as it was negligence of Saurabh. Saurabh is solely liable as Nisha was not driving the car. Nisha is liable as Saurabh was driving under her authority and for her purpose. Saurabh will be exempted from liability under the principle of inevitable accident. Now, if we apply the principle, he who does things through others does it himself. That means Nisha is doing things through Saurabh. That means Nisha is doing things herself. That means Nisha is liable as Saurabh was driving under her authority and for her purpose. Saurabh is solely liable as Nisha was not driving the car. It may appear to be a true or a correct answer for you people if you give it a summary reading, but if you read the detailed manner and you apply the principle, that ultimate answer would be Nisha is liable, because we are talking about a principle which says he who does things through others does it himself. Now here Nisha is liable because she did a thing through Saurabh, that means she has herself done that thing. So our correct answer here is going to be C. Principle res ipsa loquitur, that is, the thing speaks for itself. Res ipsa loquitur, the things or the fact speak for themselves. Situation, things speaks for itself. Seema got herself operated for the removal of her uterus in the defendant's hospital, as there was diagnosed to be a cyst in one of her ovaries. She was having ovarian cyst, so her uterus had to be removed. So she went to defendant's hospital for diagnosis. Due to the negligence of the surgeon who performed the operation, abdominal pack something was some packet, okay, was left in her abdomen. Now doctor left some foreigner object in her body. The same was removed by a second surgery. Now choose the options. Surgeon cannot be held responsible because it is merely a human error. Surgeon can be held, so it cannot be, first of all, this is a medical surgery and they have to take all care and precautions, so we cannot dismiss any negligence like this as a human error. Okay, it is not a mere human error, so this option is definitely not a good option. Surgeon can be held responsible, but Seema will have to prove in the court of law that the surgeon was grossly negligent. Surgeon can be held responsible, but Seema will have to prove that surgeon was grossly negligent. Okay. Surgeon will be responsible and Seema need not prove surgeon's negligence because presence of abdominal pack in her abdomen is sufficient proof thereof. Now, we are talking about, let's apply our principle which says things speak for itself. That means facts speak for itself. That means abdominal pack in the abdomen speak for itself. That this pack is put by doctor. Okay, because otherwise abdominal pack cannot go into the abdomen of Seema in a natural process. So something happened and something is what operation was done. So things speak for itself. Abdominal pack in abdomen itself says that it's a negligence of the doctor. So applying the principle to the fact, we'll get our correct answer, that is C. Principle. When an act which would otherwise be an offense is not that offense by reason of youth, the want of maturity of understanding, the unsoundness of mind, or intoxication of person doing that act, every person has the same right of private defense against that act, which he would have if the act were that offense. Nothing is an offense which is done in the exercise of right of private defense. Okay, it simply says that if someone is doing something to you, you have a right of private defense. Okay. A, under the influence of madness, attempts to kill B. B, in order to save his life, causes grievous hurt to A. Now, what happened here is A is under the influence of madness. A is a lunatic person, he attempts to kill B. So, A's act is not an offense. Okay, usually we have a private defense against an offense caused to us, but A's act, because he is a mad person, he does not know his act, so his act cannot be categorized as an offense. Okay, so A's act cannot be categorized as an offense, one thing. Now he is attempting to kill B. Now just because A is unsound and his act will not be constituted as an offense and he is attempting to kill B, can we expect B to just stay and let him be killed? No, definitely in this situation as well, even if this won't constitute as an offense in the part of A, still B shall have all the rights of private defense available to him. So in order to save his life, he caused a grievous hurt to A. Now let us see what has happened. A has committed an offense, A has not committed an offense, B has committed an offense, B has not committed an offense. So if you people who are here, if you people will read this thing, this question summarily, okay, in a quick manner. So sometimes ultimate answer appear to you may be A has committed an offense because it boldly says A attempts to kill B. So you may go with the A, but A is under the influence of madness. A has not committed any offense here. Okay, A has not committed any offense, but we are not trying to find A's guilt. We are talking about B. So, what has B done? Whether B has committed an offense or B has not committed an offense. B, in order to save his life, caused grievous hurt to B. So, B is doing nothing is an offense which is done in the exercise of right to private defense. So, applying this principle straight to the fact, B has not committed any offense. Whoever by words, either spoken or intended to be read, or by signs or by visible representation, makes or publishes any imputation concerning any imputation, imputation means allegation, concerning any person intending to harm or knowing or having reason to believe that such imputation will harm, the reputation of such person is said to defame that person. So this is the definition of defamation. Okay, defamation means disreputing someone, bringing down someone's reputation. Okay, so whoever by words, either spoken or intended to be read, or sign or visible representation, makes or publishes any imputation concerning any person, intending he has intention to harm, or knowing or he knows that such harm will be caused by my doing so, or having reason to believe that such imputation will harm, is said to defame the person. Now, keeping this principle in the background or in the mind, let us read the fact. In a community, there is a custom of stealing shoes of bridegroom during the marriage. Just write groom here. Groom during the marriage ceremony. The shoes of groom were stolen by Y. Okay, shoes were stolen by Y. A announced that Z has stolen the shoes. Okay, shoes were stolen by Y. Okay, A announced that C has stolen the shoes. Everyone present in the marriage party started staring at C with a great surprise. Z felt very ashamed. Okay, but shoes were stolen by Y. Now Z felt very ashamed. Now A defamed Z. A did not defame Z. A defamed Z for Z felt ashamed. A defamed the whole marriage party. Now in this case, because Z has not stolen the shoes. Okay, Z has not stolen the shoes. It is Y who has stolen the shoes. So definitely A leveling imputation of theft upon Z will defame Z. So our ultimate answer is going to be A defamed Z. '25. An employer is liable for the negligence of his employee. But an employer is not liable for the negligence of his employee if the victim of such negligence is one of his other employee. Okay, now read the facts. A and B were working in a factory as unskilled laborers. A was carrying a basket of stones on his head. B was sitting on the ground. When A crossed B, all of a sudden a stone fell down from the basket and hit B on his head. B died immediately. Okay. The owner of factory will be liable. A and the owner of factory shall jointly be liable. C. The owner of the factory will not be liable. D. None of the above. So D option, none of the above, is not a good option at all. Why? Because someone has died, so definitely someone is to be held responsible. But who is going to be held responsible? Let's see the principle. Principle says an employer is liable for the negligence of his employee. Now B is A is employee, okay, and he is being negligent. But an employer is not liable for the negligence of his employee if the victim of such negligence is one of his other employees. So A crossed B and B died. Something fell on the B's head and B died. But who is B? B is an employee. Who is A? A is an employee. Who is negligent? An employee. Who suffered? An employee. So something is happening between two employees. So if we apply the principle, principle says the owner of factory will not be liable. Okay, the owner of factory will not be liable. So our answer is answer C. Option C is the correct answer in the given situation. Damages are the money recompense as far as money can do for the violation of a right. Okay, so whatever damage has been inflicted to someone, we'll try to pay it by the money as far as practicable. Okay. A. An Indian citizen having a right to vote was not allowed to cast his vote on the polling booth by the returning officer. Name of A was mentioned in the voter list. A has also reported at the polling booth in time. However, the candidate in whose favor A would have cast his vote won the election. A filed a suit claiming damages. Okay, A will be entitled to damages, A will not be entitled to damages, A will be entitled to only nominal damages, A will be entitled to exemplary damages. Okay, now these are, so we have done this kind of question in our previous class. So we know that injuria sine damnum has happened here. Injury has happened, damage is not there, but still because injury has happened, A will be entitled to damages. Now, what kind of damages? Nominal damage or the exemplary damage. Okay, but the principle talks only about damages. Okay, it doesn't talk about nominal or exemplary damage. So we cannot keep in count of nominal or exemplary damage. Though the fact, if you read the fact, it may appear to you that because the candidate has won, so he may get only nominal damages. Okay, but this would be a wrong option. The principle is talking about only damages. The principle is not talking about nominal damage or exemplary damages. So our answer is going to be A will be entitled to damages. Nominal or exemplary, that is a different issue. First issue is whether he will be entitled to damages or not. As per the principle, the answer is yes, A will be entitled to damages. What kind of damages, how much damage, that is a different exercise which is not required by this particular question. So we'll keep ourselves restricted to the precincts of the question only. Principle: when a person voluntarily agrees to suffer some harm, he is not allowed to complain for that. A was one of the spectators at a Formula One car race being held at Gurgaon. A on a track owned by 1M company. During the race, there was a collision between two racing cars, one of which was thrown away amidst spectators, thereby causing an injury to A. A claims damages for the injuries caused to him. Now we have done this kind of question in the IPL situation, so it is very easy for us to apply the principle to the situation, and we can easily say M company will not be liable for damages because the collision between cars was beyond its control. M company will not be liable for damages because A had come to see the race on his own volition. Now, which we have to see between all these options say liable because during the race organized by it. Okay, M company is not going to be liable. So there are two options which says M company will not be liable. Now, which one is more suitable? We'll have to see. Collision between the cars was beyond its control. Okay, that is also one good option. But the principle is talking about voluntary agreeing to suffering. Now, this principle applies only to this particular option. M company will not be liable for damages because A had come to see the race on his own will. Okay, on his own will or volition. So, ultimately, our answer is going to be answer B. Hello. An interest which is created on a transfer of property and depends upon the fulfillment of a condition will fail if the fulfillment of the condition is impossible or is forbidden by law or is of such nature that if permitted it would defeat the provision of any law or is fraudulent or involves or implies injury to the person or property of another or the court regards it as immoral or opposed to public policy. Okay, now there are different conditions in which an agreement will not be allowed to be completed. Okay, so all these conditions, let us apply these conditions to the facts in the hand. A gives rupees 10 lakh to B on condition that B shall marry A's daughter. Okay, on the date of which A gave rupees 10 lakh to B, C was dead. B's interest in 10 lakh fails because of impossibility. B's interest in 10 lakh fails because of immorality. B's interest in 10 lakh fails because of prohibition by law. B's interest in 10 lakh does not fail. So definitely because the money was given only for the marriage of C, but C is dead. So interest in 10 lakh is will definitely fail. So D is not a good option. Now in all these three options, interest is failing. Now let us see. B's interest in 10 lakh failed because of prohibition by law. No, it is not prohibited to marry someone. B's interest in 10 lakh fails because of immorality. Marriage is not immorality. B's interest in 10 lakh fails because of impossibility. This is the most appropriate question here, option here, because it is impossible because C was dead. So it is impossible to carry out the contract, and when contract cannot be performed, B will forfeit all his interest in 10 lakh rupees. Now some of you may feel like prohibition by law as well because this is a dowry. Dowry is prohibited by the law, but dowry is when you forcefully demand money. When someone is willingly giving you money, that is not called dowry. So this practice, willingly giving gifts to the groom or money or land or car to the groom, is not prohibited. So there is no prohibition of law here. This is not dowry. Facts do not state it as a dowry. Facts simply state that impossibility. Okay, so our answer here is going to be A. Nothing is an offense merely by reason of its being done with the knowledge that it is likely to cause harm. If it be done without any criminal intention to cause harm, and in good faith for the purpose of preventing or avoiding other harm to a person or property. It is just kind of like we discussed in the criminal law, we discussed exceptions to the crime. Okay, when you do a crime in order to save someone else or save harm to the property, then it will not be a crime, it will not be an offense. Mr. Sherman, the Italian captain of a steam vessel, suddenly and without any fault or negligence on his part, finds himself near the Kochi coast in such a position that before he can stop his vessel, he must inevitably run down a boat B with 20 or 30 passengers on the board, unless he changes the course of his vessel, and that by changing his course, he must incur risk of running down a boat C with only 2 passengers on board, which he may possibly clear, whether Sherman has committed an offense or not. So now he has two options, either to collide with a boat carrying 30 passengers or collide with a boat carrying 2 passengers. But he must collide. Okay, but he must collide. Now let us see the options. And he has chosen the collision with 2 passengers on the boat, which he may possibly clear. He has cleared it or not, we do not know, but let us assume he failed in clearing and 2 passengers are dead. Let us see. Sherman has committed no offense because this was done out of necessity. Sherman can be held responsible for the act of criminal negligence. Can he be held guilty for criminal negligence? But the facts state that without any fault or negligence on his part, so there is no negligence at all. So this option goes out. Sherman can be held responsible for culpable homicide, killing people when his act is not criminal at all. So culpable homicide, act of killing someone also goes out. So these two options are out. This is clear case of accident, so Sherman cannot be held responsible. Okay, this is a clear case of accident, but what we are doing here is we are discussing a principle which is avoiding harm to other. That means it was necessary to be done, so the most appropriate would be Sherman has committed no offense because this was done out of necessity. This is accident as well. Okay, this option is also good, but the ultimate true option, correct option as per the question asked is option A. Okay, so you have to figure out. Sometimes it may happen a lot of times that you will have a question which may have two answers which may both appear correct, but you have to find out the most correct by applying the principle to the facts, and then you have to answer. Okay, it may also appear it is also a right answer, and it may appear right to you as well, but if you will apply the principle, then this option will automatically go out and only necessity will stay. Ignorance of fact is excused, but ignorance of law is no excuse. X was a passenger from Zurich to Manila in a Swiss plane. When the plane landed at the airport of Bombay on so and so, it was found on searching that X carried 34 kg of gold bars on his person and that he had not declared it in the manifest of transit. On 26 November so and so, the government of India had issued a notification modifying its earlier exemption, making it mandatory that the gold must be declared in the manifest of the aircraft. Okay, on 2 days, just 2 days before, the law was changed. Okay, and he was not aware of the change in the law. X cannot be prosecuted because he had actually no knowledge about the new notification issued. X cannot be prosecuted because ignorance of fact is excusable. X cannot be prosecuted because X can be prosecuted because ignorance of law is not excusable. X liability would depend on the discretion of the court. Now, in this case, principle says ignorance of law is no excuse. So definitely he is going to be prosecuted, and the ultimate answer is X can be prosecuted because ignorance of law is not excusable at all. Though on bare reading it may appear to you that what was the fault of this person, but we are not required to attach our emotions to the questions, and we have to simply put the principle and answer it. So the most appropriate answer here is C. Ramu applied for the post of director in an organization. The governing body of the organization passed a resolution appointing him to the post. After the meeting, one of the members of the governing body informed him privately of the resolution. One of the member of the meeting, which appointed Ramu as the director, informed Ramu in private that you have been appointed as a director. Subsequently, the resolution was resigned. Resigned means taken back. Ramu claimed damages. Which one of the following is the correct legal position? Ramu says that because you have decided and I accept your contract, so now I should be given director post. Now you are taking it back. You cannot take your contract back now because contract is concluded. Because the member informed me privately and I gave my acceptance as well to the member. So now the contract is complete. Let us see what is the issue here. Ramu cannot claim damages as he had not resigned from his existing post in the anticipation of getting the appointment letter. Ramu cannot claim damages as there was no formal communication. Ramu can claim damages as governing body cannot resign the resolution once passed. Ramu can claim damage as there was a private communication. Now we are talking about communication. Contract depends upon the communication of offer and communication of acceptance. Okay, so the committee decided that we'll make an offer of the post of directorship to Ramu. Okay, and they passed a resolution, but the resolution has not been communicated to Ramu by the committee. It has been informed, communicated to him privately. But private communication is no communication at all. It had to be a formal communication. But there was no formal communication, and before formal communication, he cannot accept the offer. And when there is no communication of offer, there cannot be no acceptance and there can be no contract. So Ramu cannot claim damages as there was no formal communication. So Ramu's claim will fail. Miss Usha wants to file a suit against Bhagyalakshmi Theatre, praying for a permanent injunction, stay order, restraining the theatre from running the film named Jai Santoshi Ma. Her contention is that the film hurt her religious feelings and sentiments as goddess Saraswati, Lakshmi, and Parvati were depicted as jealous and were ridiculed. In this movie, three goddesses were depicted as jealous of each other. So, Mrs. Usha sought a stay order that it hurts my religious sentiments. Now you decide what should be the case. She cannot file a suit because injury to religious feelings is not a legally recognized right. She cannot file a suit because the theatre has a fundamental right to speech and expression. She can file a suit as injury to religious feelings has been legally recognized as right. It is a case of complete judicial discretion. Judicial discretion means judge will decide. So this case is actually a real case which was decided by a court, Supreme Court of India, and Supreme Court of India had decided that she cannot file a suit because injury to religious feelings is not a legally recognized right. Okay, injury to religious feelings is not a legally recognized right, though we have a right. Okay, no one can hurt our religious sentiments. We have a legal right for that, but applying the facts in this case that because just because Saraswati and Lakshmi Parvati were depicted jealous of each other, you cannot call it as a hurting of religious sentiments. This case was taken as a case of extra sensitive plaintiff, and we cannot help any extra sensitive plaintiff. So, court had decided option A. Okay, court had decided option A in this case. So, our answer is going to be A. A person is an employee of another if the mode and the manner in which he or she carries out his work is subject to the control and supervision of the latter. Just a second, please. An employer is required to provide compensation to his or her employees for any injury caused by an accident arising in the course of employment. The words in the course of an employment mean in the course of the work which the employee is contracted to do and which is incidental to it. Facts. Messrs. Zafar Abidi and Company manufactures beedis with the help of persons known as patadars. The patadars are supplied tobacco and leaves by the company and required to roll them into beedis and bring the beedis back to company. The patadars are free to roll the beedis either in the factory or anywhere else they prefer. They are not bound to attend the factory for any fixed number of beedis. The company verifies whether the beedi adhere to the specified instruction or not and pays the patadar on the basis of number of beedis that are found to be of right quality. Ashish Matthew is one of the patadar of the company. He was hit by a car just outside the precinct of the factory while he was heading to have a lunch in a nearby food stall. Ashish Matthew has applied for compensation from the company. Okay, now Ashish Matthew says, I am the employee of a company and I have been hit by a car while I was going to have a food lunch in nearby food stall. Okay, so I must be treated as in course of my employment and company must pay me a compensation. Okay, company must pay me a compensation. Now let us see the questions. Options. Ashish Matthew is an employee of the company because the letter exercises control over the manner in which Ashish Matthew carries out BD. Ashish Matthew is not an employee but an independent contractor as he does not have a fixed salary. Ashish Matthew is an employee because the company exercises control over the final quality of BDs. Verification of quality of BD amounts to control of the product and not control over the mode and method of work. Therefore, Ashish Matthew is not an employee of the company. Now, let us see the fact and go back to the principle again. A person is employee of another if the mode and manner in which he or she carries out his work is subject to control and supervision of later. Now, in this way, they are free to roll as many BDs as they want to and wherever they want to. Okay, so there is no control on mode of rolling the BDs or manner in which or place where they are rolling the BDs. Okay, only thing they are doing is checking the quality of BDs. Verification of quality of BDs amounts to control over the product and not control over the mode and method of the work. Therefore, Ashish Matthew is not an employee of company. This is one option. Another option is Ashish Matthew is an employee because the company exercises control over the final quality of BDs. See, control of the final quality of BDs is still not a control over the mode and manner of making the BDs. Ashish Matthew is not an employee but an independent contractor as it does not have a fixed salary. Fixed salary has nothing to do with whether you are an employee or not. Okay, test is whether someone controls your mode and manner of working. Ashish Matthew is an employee of the company because the latter exercises control over the manner in which Ashish Matthew carries out his work. Okay, so we have to see whether Ashish Matthew, his place of work, his manner in which he works, how many BDs he rolls out a day, where he rolls out the BDs is either controlled by the company or not. Pattadas supply tobacco and leaves by the company and are required to roll them into BDs and bring BDs back to company. That means pattadas are free to roll BDs either in the factory or anywhere else they prefer. That means factory is not having any control on the mode and manner. They are only having quality check. Verification and quality of BD amounts to control of the product and not control over the mode and method of work, and therefore Ashish Matthew is not an employee of the company is the ultimate answer. In case the Patada were compulsorily required to work in the factory for a minimum number of hours every day, then it would be correct to state that now they are saying Pattadar, let us assume Pattadas were compulsorily required to work in the factory for minimum numbers of hours a day. That means now factory is controlling their modern manner of working. That means now they have become an employee. Now let us see in these facts. The injury was not caused by an accident in the course of employment. Ashish Matthew would not be an employee as the company would have still not exercised control over the manner of the work. The injuries suffered by Ashish Matthew could not be held to be one caused by an accident. Stipulations on place and hours of the work relate to manner and mode of work, and therefore Ashish Matthew would be held as the employee of the company. So this is the right answer, that definitely Ashish Matthew is an employee of the company because of the stipulation put on the number of hours and place of work as well. Okay, so he is an employee. But whether when he suffered the accident, was he in employment or not? Let us see where he was. He was hit by a car just outside the precinct of the factory while he was heading to have lunch in the nearby food stall. So, when he was going to have lunch in the nearby food stall, it was a lunch hour. He had left the factory premises. He was himself going on to a nearby stall. That is not part of the job. Okay, that is not part of the employment. He could have had lunch, he could have brought his lunch and had it in the factory premises, or he could have bought something from the factory canteen. But if he is going outside of the factory to have food stall, he is outside the employment. So ultimate answer is though he is employment, but the injury was not caused by an accident in the course of employment. Sadly, he will fail in seeking compensation here because he is outside his employment. But if the question would have been, fact would have been slightly different. If the fact would have been that factory does not have a canteen or a facility for having lunch and employees are required to go out to have lunch, then he would have been in the course of employment. But because we are talking about a factory, though there is nothing specified here about the canteen or the place of lunch, we always assume that factory being a area large enough where people definitely can sit and have food, and because there are people in the factory, a canteen or a some kind of pantry would be there. Okay, so unless it is stated, we will assume it because of the factory. So because he was going outside to have lunch, he would be outside the course of employment. But if the question would have stated that there is no canteen or no place to have food in the factory, so employees go out, then he would have been in the course of employment. But in this case, he is not within his course of employment. According to the facts and the rules specified, which of the following propositions is correct? The company is not liable to pay compensation as the injury to Ashish Matthew was not caused by an accident arising in the course of employment. The company is liable to pay compensation. Since the injury did not arise in the course of employment, the company would not be liable to pay compensation even though Ashish Matthew is the employee of the company. The company is liable to pay compensation as Ashish Matthew is contracted patadar with the company. So now we have discussed it enough. So ultimately answer is going to be C, because though he is still an employee, but he is outside his employment right now presently when the accident happened, so he will get no compensation at all and company will not be liable, and the ultimate reason for no liability of the company is option C of the question 35. Select the statement that could be said to be most direct inference from the specified facts. The injury to the Ashish. Now we have to select the most direct inference. Okay, most direct conclusion which we can draw. That means all conclusions are true somehow, but we have to find out the most direct inference from the specified facts. The injury to Ashish Matthew did not arise in the course of employment as he was not rolling BD at the time when he was hit by the car. Since the Ashish Matthew is a contracted patada with the company, it shall be presumed that the injury was caused by an accident in the course of employment. Since there was no relationship of employment between Ashish Matthew and the company, the injury suffered by Ashish Matthew could not be held to be one arising in the course of employment, notwithstanding the fact that concerned injury was caused while he was involved in an activity incidental to his duties, as the concerned injury was caused to Ashish Matthew while he was involved in the activity incidental to his duties. The injury did arise in the course of employment. So now again we'll go back to option A. The injury to Ashish Matthew did not arise in the course of employment as he was not rolling BD at the time when he was hit by the car. His employment is to roll BDs. He was not doing so. Okay. Since Ashish Mathew is a contracted Patadar with the company, it shall be presumed that it was in the course of employment. A contractor is not an employee, first of all, so this option is not a good option. Since there was no relationship of employment, there was a relationship of employment, so this option is also not good. Okay. As concerned injury was caused to Ashish Mathew while he was involved in an activity incidental to his duties. Having lunch is having nothing to do with his duties. Okay. Okay, so he could have had lunch in the factory within factory, but going outside the factory is not a part of his job, like we just discussed. So ultimately, this inference is the only most correct inference from the specified facts. If the Pattadas were compulsorily required to work in the factory for a minimum number of hours each day, then company would have been liable to pay compensation to Ashish Mathew if latter means if Ashish Mathew had been assaulted and grievously hurt by his neighbor inside the factory premises over a property dispute, had slipped and fractured his arm while trying to commute on city bus from his home to factory, had been injured while commuting on a bus provided by the company and which he was required by his contract to use every day, had been caught in the middle of crossfire between police and a gang of robbers while traveling to work. So in these situations, which is the most appropriate situations in which he would have got the compensation? Had been assaulted and grievously hurt by his neighbor. That is a private enmity. Private rivalry, company is not liable. This option is out. Had slipped and fractured his arm while trying to commute on city bus from his home to the factory. It may be right. It may be right. Okay, it depends on the situation. But had been injured while commuting on a bus provided by the company, which he was required by his contract to use every day. This is the most appropriate answer. Okay, because he was traveling from the bus provided by the company. That means the moment he sits on the bus provided by the company, he is on his course of employment. So when he is in course of employment, he will get compensation. He may get compensation in this case as well, but this case will depend on a lot of different things. But in this case, straight away he'll be eligible for compensation. Had been caught in the middle of a crossfire between police and a gang of robbers. So now company has nothing to do with the police or the gang of robbers, so they cannot take responsibility for what is happening between a police and robbers. Okay, so company will not give any compensation to Ashish Mathew in this case. So the only ultimate case in which Ashish Mathew will get a compensation is option C here. Principle Rule 1. An owner of land has the right to use the land in any manner he or she desires. The owner of land also owns the space above and depths below. Okay. So if I am the owner of the land, I own the space above my land and I own the space below my land as well. Okay, this is the principle which is saying. Rule B. Rights above the land extend only to the point they are essential to any use or enjoyment of the land. Rights extend. Rule B is right extend only to the point essential. Okay. Point C. Rule C. An owner cannot claim infringement of her property right if the space above his or her land is put to reasonable use by someone else at a height at which the owner would have no reasonable use of it and it does not affect the reasonable enjoyment of his or her land. These are three principles. And now this is the fact. Ramesh's case. Ramesh owns an acre of land on the outskirts of Salurpeta, Andhra Pradesh. Salurpeta, Andhra Pradesh. The government of India launches its satellite into space frequently from Sriharikota near Salurpeta. The government of India does not deny that once the satellite launch has travelled the distance of almost 7,000 kilometers, it passes over Ramesh's property. Ramesh files a case claiming that the government of India has violated his vested rights by routing satellites over his property, though 7,000 kilometers directly above it. Now, applying Rule A to Ramesh's case, as a judge, what would you decide? In favor of the government of India because the transgression was at a height at which Ramesh could not possibly have any use. 7,000 kilometers above the land, what could Ramesh do with it? even very high in the space, 7,000 kilometers just near the moon. How can Ramesh own it? Okay, that the ownership of land does not mean that the owner's right extends infinitely into the space above the land. In favor of Ramesh because he has the right to infinite space above the land he owns. In favor of the government of India because it would lead to the absurd result that Ramesh and most other property owners would have a claim against the airline companies and other companies of the world whose satellites orbit the earth. Definitely, aeroplanes travel in the space and they cross several properties beyond below. So people are going to file cases against them if we allow this rule. So ultimately, in this case, the correct answer is going to be C in favor of Ramesh because he has the right to infinite space above his land. You must be startled that why I am making such an unreasonable statement and why am I choosing such an unreasonable answer because the question states applying only rule A to Ramesh case. What is only rule A? An owner of land has the
It's
right to
9
use of the
o'clock.
land in any manner he or she desires. The owner of land also owns the space above and depths below. We are applying only rule 9, rule A. You don't have to go into the emotional arguments, okay, that this should not be the case. 7,000 kilometer, what we'll do, she'll do. This is just trying to googly you, okay? Don't let people googly you. Just read the question very straight away. Answer rule A. Yes, in favor of Ramesh, if rule A. Shazia's case. Shazia owns a single storied house in Ahmedabad which has been in her family for more than 75 years. For more than 75 years, the foundation of the house cannot support another floor, and Shazia has no intention of demolishing her family home to construct a bigger building. Javed and Sandeep are business partners and own three-story houses on either side of Shazia houses. Javed and Sandeep are also Ahmedabad's main distributor for a major software company. They have erected a huge hoarding advertisement advertising their products with the end supported on the roof. But the hoarding also passed over Shazia's house at 70 feet and cast a permanent shadow on her terrace. Shazia decides to hoist a huge Indian flag going up to 75 feet on her roof. She files a case asking the court to order Javed and Sandeep to remove the hoarding for all these reasons. Now, they have put up some hoardings on their own roof, but shadow is going on the roof of Shazia. Shazia's house is single story house. Her house is in a dilapidated condition. It cannot support another story on it. Okay, and she has no intention of demolishing and rebuilding it again. But because she is jealous of their hoarding, putting shadow, casting shadow on her roof, she decides to have a 75-feet Indian flag on her roof. And now she wants Javed and Sandeep to remove the hoarding because of this reason. Applying only rule B to Shaja's case, you would decide in favor of. Now apply only rule B. What is only rule B? Rights about the land extend only to the point they are essential to any use or enjoyment of the land. Now let us see. Javed and Sandeep, you would decide in favor of Javed and Sandeep because Shazia can easily hoist a flag below 70 feet. Shazia because she has a right to put her land to any use and court cannot go into her intentions of hoisting a flag at 75 feet. Shazia because she has absolute right to space above her land. This option is not there. Absolute right is not there. This is only as rule A. So this is not applicable in rule B. This will go away. Javed and Sandeep because hoisting is 75 feet above one's roof is not essential to the use and enjoyment of land. Okay. Now, who is going to decide what is essential to the use of land? Okay, she can have reasonably, she can enjoy her land, and 75 feet is not unreasonable height, it is a reasonable height. Okay, so answer here is Shazia because she has right to put her land to any use and court cannot go into her intention of hoisting a flag at 75 feet because she has right to reasonably enjoy, and 75 feet is not a very great height, so putting a hoisting a tricolor at 75 feet height is not unreasonable. Okay, so she will succeed here. As a judge, you will have to decide in favor of B, in favor of Shazia. Okay. Applying only rule A and B to Shazia's case, you would decide in favor of Shazia only under rule A, in favor of Shazia under rule A as well as B. against Shazia under rule B, against Shazia under rule A and B. So ultimate answer is B, because rule A, she has ultimate right to space above, and as well as B because she can reasonably enjoy it. So we'll go with option B, both of them. Applying only rule B and C to Ramesh's case, you would decide. Now we go back to case of Ramesh. In favor of Ramesh only under rule B. Now let us see what is the case of Ramesh. I forgot it. Okay, Government of India, satellite. In favor of Ramesh only under rule B. In favor of Ramesh under rule B and C, B and as well as C. Against Ramesh under rule C. Against Ramesh under rule B as well as rule C. Rule B is essential. So, in this case, we will decide against Ramesh both under rule B as well as rule C, because 7,000 kilometer above his house, we cannot expect him to enjoy something at that height. Plus, that will unnecessarily interfere. That will, because it is put at reasonable use by someone else at height at which the owner would have no reasonable use at all. 7,000 kilometers is a great height. So will Ramesh will get defeated in the case in rule B as well as in rule D. C. Applying rule C to Shazia's case, would you decide in her favor because hoisting a 75 feet high flag is reasonable, against her because 75 feet high flag is not reasonable, against her because the hoarding is reasonable use of the space above her land, in her favor because the permanent shadow cast by the hoarding affects the reasonable enjoyment of her land. Okay, in this case, rule 3, rule C deals with reasonable use by someone else of your space which does not interfere with the right, but because it's casting a permanent shadow, it is affecting her enjoyment. So we'll go as per rule C, will rule in favor of Shazia, going with option D. Okay, now time's up. We'll meet in the next class. Thank you.